morning, good afternoon, good evening to all of you. We want to just take a small journey into corporate or company and incorporation. A company is an entity that have been registered in a particular jurisdiction to undertake some activities. It is a company because it is registered under the laws of the country. When that is done, the company has full identity and the company has a full legal entity. As soon as the company is incorporated or registered in the jurisdiction, that company has powers to undertake activities, powers to undertake some objectives as set out. When a company has powers, the company is supposed to work within the powers granted it by the Companies Act. When a company is formed, the company is supposed to do everything in line with the requirements of the Companies Act. The company becomes a company because the registrar of companies has issued certificate of incorporation. It is that certificate of incorporation that gives life to the company. So when the company is formed, as established in the old case of Solomon versus Solomon, that company assumed a separate legal entity from the owners, a separate legal entity from the officers of the company. And this separate legal entity is very important. This separate legal entity gives some kind of covering to the directors and key officers of the company operating in the interest of the company. The company can be sued and be sued. But when we talk about incorporation, incorporation is a process through which a company is born. Incorporation is a process within a jurisdiction. That process is described in Section 13 of the Companies Act 2019 at 992. First of all, the Companies Act provides who is supposed to incorporate a company in Ghana. And the company law says that if you're 18 years and above and of a sound mind and without any criminal records, especially criminal records regarding financial fraud and incompetence of attempting to incorporate a company, then you are qualified to incorporate a company in Ghana. The process starts with completing an application form and submitting same and paying the required administrative fees to the registrar of companies. Then the registrar of companies scrutinizes your document and becomes satisfied. Then the registrar of companies will issue certificate of incorporation. Then the company is born. The completion of application is the paramount step that is needed to incorporate a company in Ghana. The form requires certain things to be part of the process. Number one, we want to know the name of the company that is proposed. And the name of a company is very important and crucial. because the name should not be misleading. The name should not be an existing name of a company. The name should not be pointing to some kind of evil in the jurisdiction. For example, you cannot have a name like We Smokers Company Limited, because that is not desirable. So you shouldn't provide a name which is undesirable. So the name is also very important in the process of incorporation. Then the subscribers. The subscribers are very, very important. They are the people who are starting the company. So we need to know their names. There are four names, their former names, if there is any. Having done that, we need to have a statutory declaration to indicate that in the past 5 years, these people have never involved themselves in any fraud relating to finance or any fraudulent activity. So the word is charged and convicted. They are not charged and convicted for crimes that are aggravated in nature. Then we need to know the proposed, but before then, these subscribers, after the incorporation, the law says that they become the first members of the company. As was the decision in Adishima Gardens versus Asibe, where the subscribers of the company have become, as of a right, members of the company, after which any other person who buys shares in the company becomes a member of the company. So that is the important role that subscribers to a company plays. Because of the role they will be assuming when the incorporation takes place, we need to scrutinize and know that their names are well spelled out, their addresses are well spelled out, and if they have any former names, those names are recorded. Then the application form also require that the names of proposed directors be given, including if there is any former name, they should provide statutory declaration that they have not involved themselves in any crime in the past 5 years. The law also requires that a company should not have short of directors, or a company should not have less than 2 directors. If a company has less than 2 directors, the company is on the way to incur administrative penalty. Then some other officers ought to be indicated and their records provided, such as the secretary. The secretary is a very important officer of the company. In fact, in the Panorama case, Lord Denning says that they are so important that if they engage in some contracts relating to the administrative duties, those contracts are binding on the company. So they also provide their records. Likewise, the proposed auditors of the company. It is the auditors who authenticate the financial dealings of the company, whether they are in line with the rules or not. So they are also very important. So when all these documents are provided and they satisfy the director, the registrar of companies, then the registrar of companies issues certificate of incorporation. So that is incorporation. So the incorporation is a process, and the corporation or the company is an entity that have been registered in the jurisdiction, complying with the Companies Act. So the moment the company is formed or is registered or is incorporated, that company is under obligation to act in line with the Companies Act. The rule of thumb is that when the company is registered or is incorporated and does not provide a constitution of its own, then the company is bound by the scheduled constitution attached to the Companies Act. But if the company develops its own constitution, that constitution is registered, then the company will be bound by the details of its own constitution, unless the constitution is at variance with the provisions of the Companies Act. So incorporation is very crucial, it's very important, because when incorporation is consummated or is executed, it defines so many responsibilities, powers, and authorities for the company and its officers. So when the company's constitution is registered, it means that the company has undertaken to abide by its own constitution. If the company acts beyond the provisions of its own constitution, it acted ultra vires. So the issue about incorporation is a very crucial one. It's very important and fundamental to the study of company law. So in summary, a company is registered in a jurisdiction and assume powers and authority, can enter into contract in line with the Company Act, can be sued and be sued, has officers who act on its behalf, and so long as those acts are in consonance with the Companies Act and the constitution of the company, there is no problem. All officers of the company are obliged by the Companies Act to act in the best interest of the company. In fact, the company law qualifies fiduciary responsibility towards the company. A company, as properly defined by the Companies Act, can be a private company or a public company, can be limited by shares or limited by guarantee. The company, when formed, is required to have board of directors. Is required to have board of directors. And this board of directors are supposed to administer and guide the operations of the company, and must be done with utmost good faith and due diligence. A company, when formed, has powers to exercise. If it's limited by shares, that company, and it's a public company, that company has power to invite the public to flow share to them. That company has power to issue debentures. If it's a private company, that company is required to have directors, but it's limited to doing so many things. It cannot invite the public to flow share to them. It cannot issue debentures to the public. Its number will be limited to 50 when it is a private company. If it is not a private company, its number will not be limited. to 50. And I did say, if you talk about incorporation, then you are on the way to execute a process. You're on the way to start a process, and that process starts with completing an application form and submitting the application form to the registrar of companies for scrutiny and acceptance. When it is accepted, then a certificate of incorporation is issued with the payment of the appropriate administrative fees. So that is the beginning of company law, company and incorporation. Thank you.